I am a lawyer, but I am not necessarily your lawyer. The materials discussed in this podcast are for informational purposes only and should not be deemed legal advice. If you have a specific legal question according to your circumstances, then I encourage you to speak with an attorney licensed in your jurisdiction. All right, welcome back to another edition of Ag Law Today, and we have a very special guest. We have Tiffany Dowell Lashmet from Texas A&M University Extension. I met Tiffany many moons ago. When was it, Tiffany? It was at least a decade ago.
It's been at least 10 years.
Yeah, I think we were newbie ag lawyers, ourselves just fresh out of law school at the time that we met. So it's certainly been a good ride. So Tiffany is going to be talking about a very important topic here today, landowner liability protections. And actually just a few days ago, Tiffany, I was having a conversation with another farmer, and he was asking me about topics for upcoming podcasts. And I mentioned this one. He was like, oh my gosh, like that is so important. So why don't you just kind of lead off a little bit on, what are some of the major issues in terms of landowner liability protection that farmers and ranchers should be aware about?
Yeah, Carrie, I mean, I'm with you. I speak all over, primarily here in Texas, but across the country. And I think that this is one of the topics that maybe is the most overlooked, and one that the ways to protect yourself are probably the simplest if you know what to do and you look into doing them. And so what I always tell landowners is there's a whole kind of menu of options you can do to try to protect your operation from liability, but you've got to take the steps up front. Once somebody gets injured, it's too late. And so I really encourage people, think about these issues. We're going to talk through, 5 or 6 different things that folks can kind of do today just to give you an idea of what's out there, what things you should be looking into. Because look, the fact is that crazy things happen, and I hope that somebody never needs this, but the odds of, an injury occurring on your land or with your animals or something like that, and you getting sued, unfortunately, are fairly high. And so having these protections in place, I think, is so important for anyone involved in agriculture.
What do you think is the number one most important thing for landowners to think about?
I think that the most important thing, I preach this, is you've got to have liability insurance. And I know that you did a whole episode on insurance with our friend Jesse Richardson from West Virginia, but I just can't overstate the importance of every landowner having liability insurance. And I think a couple of reasons, right? One thing about insurance, we all sort of understand that you have policy limits and that insurance company will cover you, up to a certain amount if somebody gets injured and there needs to be a settlement. I think what we overlook oftentimes is that liability insurance policies also provide a defense to you. So in the event that I get sued because someone gets injured, my first phone call is to my insurance company. They hire me a lawyer on their dime to get me out of that case. And that's worth a lot of money and peace of mind. So I think having liability insurance, number one thing every landowner should do.
Okay, so let's break that down a little bit, because in my podcast, we even talked about how there's so many different kinds of insurance, right? So we have like the main property liability insurance for farms. I guess we is usually termed like farm owners comprehensive liability policy, but there's also other kinds of insurance. And so what would be the kind or kinds multiple that landowners should think about?
Well, in true lawyer fashion, I'm going to be super helpful and tell you that it depends. But the kind of basic thing I think you need to have is just a basic farm and ranch liability policy that covers your operation. And the point you make is a good one, Carrie. I always tell people, I don't care the title of it, whether it's farm and ranch liability or commercial farm and ranch or whatever. I don't care. What you need is just basic coverage in the event that someone is injured on your property. That's what I think everyone needs. Now, from there, the next thing I always advise people is you have got to visit with your insurance agents about what you have going on your property. And the way that I describe it often is the further you get away from cows grazing in the pasture or corn growing in the field, the higher your odds are of needing additional insurance coverages. So for example, if you've just got cattle that are grazing, probably that farm and ranch liability policy is fine. But let's say you decide to open a petting zoo, or you decide to sell, boxed beef that you're sending to people in the mail. We're getting further away from that field, and now your regular farm and ranch liability policy may not cover that. That's where you're going to need to visit with your insurance agent and see if there's some sort of endorsement you can get that adds additional coverage for different activities.
Okay, so 2 questions, Tiffany. First question is, how much coverage does a farm or ranch really need, right? To what level? And then the second question is when a farmer or rancher is having those conversations with the insurance agent, I mean, how dependent should they be on those conversations? And what I mean by that is if a farmer rancher says, well, I'm doing XYZ activity, can we make sure that I have coverage for this? Should they just assume that it's covered in the insurance, or do they need to take it to somebody to review the insurance to make sure? I'm thinking about a recent example that I heard had to do with a county fair, and the insurance, they thought that it covered rodeo activities, and it turns out somebody got hurt and it did not cover rodeo activities. And so there's a little bit of a detrimental reliance argument there. But I guess, how dependent should farmers and ranchers be on those conversations?
Good question. Okay, so I'll take the first question was, how much coverage do you need? Again, I'm going to tell you, it depends on what you're doing. And I sort of think of it as like a totem pole, right? We've got one place that no one hunts on. We only have cattle there. We have insurance, but it's a pretty low level because our risk isn't super high.
Mm-hmm.
I took my kids to a pumpkin patch last year in the fall, and it was great. And all I could see was potential liability situations everywhere I looked, right? So they're high on the totem pole, and they're going to need a lot more coverage than I do. And so that's where you've got to sort of do some considering of what risks that you have. One thing I will note on this is if you price liability insurance, it's usually not that expensive. Now, if you have like your liability and your property all together, that bill is going to look more expensive. But you'd be surprised at the amount you're paying just for the liability coverage. It's not that much. And oftentimes to go up a significant amount, like maybe from 100,000 to 500,000 or 500,000 to $1 million, a lot of times adding that additional amount, very insubstantial as far as cost goes. So I'd really,
$2,000.
exactly. Yeah, I'd really look into that.
Yeah.
Your second question, as far as those conversations with insurance agents, the first thing I would say is you need to make sure you've got a good agent who understands agriculture and who understands what you're doing. And that's something that's easy to overlook. It's very important. So I'd really encourage that. The second thing is any conversation you have with that insurance agent, any sort of representation that they make, I always make sure to get confirmed in writing. So for example, I talk to my insurance agent, I say we're doing XYZ, they say that's covered under your policy. I then will send a follow-up email and say, per our conversation today, my understanding is, that rodeo activities are covered under our policy. If that's incorrect, please let me know. That's not going to guarantee you coverage under the policy if you don't have it. But what that does do is it gives you a potential claim against that insurance agent if there was false information. And so I think doing that is really important. The one other thing that I would advise folks to do is review your insurance policy about once a year. I know that they're no fun to look at. They're impossible to read. They're hard to understand. You'd be shocked at what you can pick up just flipping through that once a year. Check for things like, do I see an exclusion here that's something I'm clearly doing? Are all my properties listed? If you're, have equipment scheduled, do I still own that equipment? A yearly review of that policy can be really important to A, make sure that you have the coverage you think you have, and B, it can save you some money if you catch things that don't need to be insured anymore.
So regarding the coverage questions, a general rule of thumb that I tell my clients, Tiffany, and let me know if you disagree with this, is at minimum, a farmer or rancher should have enough coverage to meet the amount of assets that they have in terms of land, right? And they might also want to have additional coverage if they have farm equipment and cattle, just to basically, and have that be like a minimum amount of coverage. What are your thoughts there on that, Tiffany?
Yeah, I think that's good advice. I mean, right, just from a risk management perspective, I mean, I think that's a smart thing to do. The one other thing I might look at, and I think we're going to talk about these a little bit later, check any limited liability statutes in your state to see if there are any sort of insurance requirements that can get you protections. For example, here in Texas, under the Texas Recreational Use Statute, if you carry a certain statutory level of insurance, that makes that statute applicable to you and gives you some limited liability. That's the one other place I would check, is if there's any sort of statutory benefits to carrying a certain level of insurance.
So regarding umbrella insurance, I know that that's a fairly cheap way to add a higher level of coverage. And I don't know your thoughts, Tiffany, but I hate the word umbrella
Me too.
because I feel like you visualize this overarching shield that's going to hide any holes in your existing policies, when really it's a top hat. So
That's
whatever
right.
you have, it's raising the limits. So what are your thoughts on umbrella policies? And again, like how much umbrella should a farm or ranch get?
Yeah, I explained it exactly the same way that you just did, Carrie. The term umbrella is misleading because it makes you think it covers everything. That's just not what an umbrella policy does. And so what I think that it's important to understand is even if you have an umbrella, you have a baseline liability policy, right? And that lays out what is covered and what is not covered. All the umbrella does is add an additional dollar amount of coverage to it. It does not increase the scope at all. So in the example that you gave, if that county fair had a umbrella policy, it would have given them, let's say maybe they would have $5 million instead of $1 million. It would not have covered the rodeo if that base policy didn't cover the rodeo. So again, that's why reviewing that base policy is so important. And like you said, I think umbrellas can be a great way to add additional amount, dollar sign amount of coverage in an affordable manner. A lot of times it's cheaper to do that than to purchase a policy for the same amount. So I would sure shop that. But just understand that, because I think that's a real misconception that people have. And they think that they're really safe because they have an umbrella policy. That may not be the case.
So regarding the insurance agent, how can a farmer or rancher be sure that they're in good hands, that they're with an insurance agent that really understands agriculture production?
I think a couple of things there, right? I mean, one of them, I think a lot of times if you just talk to them a little bit, it's pretty easy to figure that out, right? If we're talking about, the cattle that we have, or, something about related to yields of corn or something like that, and they are deer in the headlights, or they say something that's just completely wrong, that's a red flag to me that I better be looking somewhere else. Another thing for me, anytime an insurance agent says something along the lines of, we'll just assume, or probably, or like, oh, I'm sure that it's X, but no, insurance doesn't work on assumptions. And so I'm always really careful about that. And if they are going to say something like that, I want that confirmed to me in writing. As far as where to find an insurance agent, I mean, there can be great insurance agents with any company that understand agriculture. I know a lot of folks that farm and ranch on the side and have an insurance agency. They're terrific. If you really don't know where to start, one place to look, I mean, at our extension programs, we frequently have insurance companies that sponsor extension programs. That says to me they're in the farm and ranch business. They're interested in having those clients. That might be another place. Just look for somewhere to start looking for an agent.
So in terms of a lease situation, right, with a farm or a ranch lease, should both the landlord and the tenant have insurance policies, or only the landlord or only the tenant?
I'm always going to answer with both there. I mean, you and I, Carrie, paid a lot of money to be professionally trained paranoid. And so I think that that's the answer. For sure, what I always suggest to people from the landowner perspective is I would have a liability insurance policy on that property. I also would require my tenant to carry liability insurance of a certain amount. And then the tenant should list the landowner as an additional insured. What that does is it gives that landowner coverage under that tenant's policy as well. And I just think that that's a smart thing to do. Now, from the tenant perspective, even if that wasn't required in a lease, I really would recommend that a tenant carry liability insurance because, again, they're the one who has sole possession of that property. If something occurs, the odds of them being sued is fairly high. And having that liability coverage just really provides them with some peace of mind and some protection.
So in terms of a farm lease negotiation, would you consider this insurance obligation, both in terms of the landlord and the tenant responsibility, to be included in there?
Yeah, it's something that I really suggest be put in a lease. And I'm sure there's exceptions to this. Most tenants don't balk too much at that. because what we talked about, it's not that expensive to get that level of coverage, and it's good for them anyway. And so a lot of times what I see, a landowner requires that in the lease. The tenant can give them like a certification of insurance that just shows I have this level of coverage on this property. It's pretty simple to do.
So I've been getting a lot of questions lately, Tiffany, about liability waivers, right? It's like maybe they have something where the general public is coming to their farm, like whether it's a pumpkin patch or something else. Or I have one client who does like classes on his farm,
Sure.
And so what are your thoughts on general releases or liability waivers? Do they really hold up in court? Does the answer to that vary from state to state?
Yeah, I think the answer probably does vary from state to state. In general, I think most courts will enforce liability waivers. The kicker there is they've got to really comply with the law of the state. And so, whatever state you're in, you need to make sure that you understand the requirements of the waiver, what has to be included, who can sign it, when does it have to be signed, those sort of details. One thing that I've seen, I know that it's an issue in Oklahoma. It's a potential issue here in Texas as well. One caveat to that, a court may be hesitant to enforce a liability waiver that's signed by a parent on behalf of a minor child. In Oklahoma, courts just won't enforce those. Minors can't waive, or parents can't waive minors' rights to recover. So that might be one place to especially look. But a liability waiver, again, we're looking at something that is fairly inexpensive to give yourself some protection there. By having someone sign this waiver that, just basically says, I'm coming on your property. I understand there are risks associated with things like a pumpkin patch, or in Texas, hunting is the big one. And I'm going to say I'm not going to hold you, liable for negligence if I get injured. I think, having that kind of waiver in place is really important. Just make sure that it's written in a way that comports with the law of your state.
Great advice. What about signs, like warning signs that farmers and ranchers can put up on the property, like beware of dog, or in my life, beware of crazy chicken? So
right.
Do they hold weight? Do you recommend them?
So the reason that a warning sign could be useful, and again, this differs a bit from state to state, but Carrie, you think back to law school, right? And we would talk about, there's different levels of duties you owe to certain people on the property. And if somebody comes on your land, it may be that you have an obligation or a duty to warn them of dangerous conditions on the property. One way to make that warning is to put up a sign, right? So, and I always tell people, at least under Texas law, what we really are talking about here are hidden conditions that somebody might not be aware of. So if, for example, if you've got an old abandoned well on your property, that's something that you probably better have a sign up or make some sort of notification of if you've got people coming to hunt, for example. And so I think that can be really important. As far as the beware of dog signs, again, I think that's something I would look at your state law about. It can be useful to warn people and hopefully keep there from being a situation. The one thing that worries me a bit is if you're in a state where you're not liable, if you don't know the dog has any dangerous propensities. I worry a little bit about if hanging up a warning sign indicates maybe you did know about dangerous propensities. I've never seen a case on that here in Texas, but I always hesitate at least a little bit. And I tell people, if your dog's never done anything bad before, I'd at least think twice about hanging that sign up. If your dog's already bit somebody, the ship sailed, hang the sign up. So
yeah, that's a good point. Let's talk a little bit about business entities. I had a farmer in my office here this morning, Tiffany, and one of the things that we were discussing was choice of entity, the advantages and perhaps even the disadvantages in forming a corporation, a limited liability company, a limited partnership, etc. How does that come into play with landowner liability?
yeah, and Carrie, this is an area that, I just think of you as being an expert on as far as entity selection, entity creation. And so you're great at it. And so I think that's a fantastic service that you provide to your clients. As far as liability protection, like you said, I think that's one piece and one potential benefit of setting up an entity. It's not the be all end all. And you should never sign up for an entity solely for the liability protection without thinking about how that may affect you in other ways, as far as things like taxes, as far as how the complicated way you have to manage things, et cetera. So there's other things to think about. Program payment limits from FSA can be a huge one to think about. As far as liability goes, there is an advantage to setting up business entity or entities for your operation, because if your operation is owned by the entity and not by you personally, if something happens, it's only the entity's assets that can be at risk, not your personal entities. It sort of provides that layer of protection there. One example that I use a lot and I think is a good one is there's a family here in the Panhandle that owns a family farm and a custom harvest business, right? Because driving combines up and down the road is fairly dangerous, they have two LLCs. The family farm is in one LLC, the custom harvest assets are in another LLC. Okay, so if one of those combines is in an accident and they get sued, it's only the custom harvest assets that could potentially be at risk. The farm is protected, their personal assets are protected. So that's how those entities can be used to offer that limited liability.
Yeah, absolutely, Tiffany. As a caveat to that, with separate entities, you need to also make sure that you're not commingling any assets, that you're adhering to corporate formalities, etc., or the court could pierce the corporate shield. So, Tiffany, you touched on this earlier in our conversation, but I wanted to dive a little deeper. Can you talk a little bit about these liability statutes in different states, and what have you seen in terms of trends in different states?
Yeah, this is a huge issue. And of all of these things, I think this is the one that most landowners and producers know the least about. And there are a number of different liability statutes in most states that offer liability protection to a landowner. Essentially, they kind of change the rules in favor of an agricultural landowner if somebody gets injured. There are kind of three types of them that I want to talk about today. The first one's called recreational use statutes.
Mhm.
The second one are agritourism acts, and then the third one are equine acts. Some of them overlap in certain ways, but they're each separate potential protections, separate potential defenses if someone gets injured. And I would encourage everyone listening, look up your states and see which of these statutes you have. Look at the provisions and make sure that they apply to you. One easy way to do that, Carrie, and I know you work with them as well, is the National Agricultural Law Center. They've got a website where you can go and you can pull up a map of the United States for Agritourism Act, Recreational Use, and Equine Act. Click on your state and it'll pop up whatever law exists. So that's a real easy way to find those.
I love their resources. I don't know about you, Tiffany, but when I first became an ag lawyer, I came across their resource library, and they just have some fantastic resources that are available not only to lawyers but to everybody in the agriculture industry. So really encourage the listeners to check out that website.
For sure.
I guess it's called the reading rooms, or is that an old school?
So if you go to their, that's old school. Yes, that's what I still call it, Carrie. But if you go to their website, at the top there's something that says research by topic. You'll see the topics, and you can find the compilations of each of these. And if you want to talk a little bit about the three different kinds of statutes, I'm sure happy to do that.
Yeah, let's do that. Let's just take it one by one, Tiffany, starting with the recreational use statute. What is it? Why do we have it?
Sure. So, and again, right, I'm going to give you the caveat that these all differ by state. The specifics are different. The general idea here is we want to encourage private landowners to open their property up to the public for recreational uses. All 50 states have a recreational use statute that, like I said, it just gives some limited liability. It changes the rules in favor of the landowner. So for example, if you have a ranch and you're going to have someone come hunt there, this statute, if it's applicable based on the different requirements, it would change the liability and in general would make you not liable for injuries to that hunter. And so it can be very useful. A lot of times they're very easy to qualify for. You just need to look at the specifics for your state.
So you said injuries to the hunter, but what if somebody is hunting on your property and, God forbid, shoots somebody, right? Or injures another person in some way? Does it also protect that instance?
Yeah, in that situation, it's likely going to be dependent on what the person who is injured was doing. If they were hunting along with someone, the question's going to be, was the injured party involved in a recreational activity? If they were, then the statute's likely going to apply so long as you have satisfied the requirements. Now, if somebody was injured and they were sitting on the porch doing nothing, maybe that's different. But if they were involved in a recreational activity and an injury occurs, this comes into play. And so the scope of each state's rule is different. At least in Texas, it covers a variety of activities from hunting, fishing, swimming, riding four-wheelers. I mean, there's a ton that are included. And the other thing to check into is whether it applies to paid participants or only people who are there for free. I looked at a couple of examples. In Texas, it applies to, even if you are paying to come and do these activities, the statute can still apply. In Oklahoma, I believe that you have to be there without charging a fee. So check that when you're looking at the statute for your state.
Are there some exceptions to that rule? I'm thinking about like any like willful wanton or gross, negligence on behalf of the hunter.
Yes, and those are the exceptions that we commonly see. The Texas statute spells out that the statute does not apply if the injury was caused by an intentional act or by gross negligence. And I think that's what you would expect, right? Because you're not going to have a statute that protects you if you're intentionally injuring someone on your property. So there are limitations to that. But for most people, this provides a pretty good degree of protection.
Okay. And does that only protect farmers who are in agricultural districts? I mean, are there some certain limitations there?
That too is going to differ by statute. I believe that there are some sorts of limitations in different states. In Texas, it applies to anybody who's got agricultural land, and we define that very broadly here. There sure may be limitations by district. In Oklahoma, I'm not sure if it's their recreational use statute or their Agritourism Act. I know there that they have to actually register with the state to get the protections. So again, that's where, making sure you look at your own state statute can be really important.
Right. I guess I'm just thinking, similarly, if you compare to like a right to farm law, right, it would only be applicable to farms that are performing sound agricultural practices in an agricultural district. So it might be similar in some of these states.
Mm-hmm.
All right, let's move on to the Agritourism Act statute. So here's a question that I receive a lot is like, what exactly is agritourism?
Sure. And I'm not helpful to anyone in this podcast, Carrie, because I'm going to tell you again, it depends on the definition in your statute. About half the states have agritourism statutes. These are fairly new. A lot of the recreational use statutes came about in the 60s and 70s. Agritourism acts, a lot of them have been passed in the last decade or so. So they're fairly new, and who they apply to, again, depends on the statute. Here in Texas, when ours came out, I kind of didn't pay much attention initially because I thought, well, I don't have a pumpkin patch. We don't have a corn maze. This isn't going to apply to us. The way it's written here, it can apply to any agricultural land where there's a recreational or an educational purpose, or that's what the person is there for. So it can be really broad. And again, that's where you want to, make sure and look at your statute. If you're doing some sort of activity, recreational, educational, those sort of things, the classes that you mentioned that one of your clients is teaching at their operation, it would surprise me if your state statute didn't cover that, but that's something you sure want to check.
Yeah, I just think about how the definition of agritourism, when I just first started practicing ag law, it just seemed to be very much like you said, like pumpkin patches, pick your own, corn mazes, hay rides, etc. But people are now hosting weddings on their property.
Sure.
They're having concerts. There's just a lot of things here that can be considered agritourism.
And that's where you've got to check with your state. For example, in Texas, we've had a case come out. It was just what you said, outdoor wedding venue, one of those barns, right? Everybody's turned their barn into a wedding venue. And the injured party was a wedding attendee. And we have a court case at the appellate level that says attending an outdoor wedding is not a recreational use. And so the recreational use statute and the Agritourism Act would not apply. Now, if they use that exact same venue and they were having some sort of class on horticulture or something, and the person got injured, that's an educational activity under our statute that the statute would apply. So that's where, knowing the nuances and visiting with an attorney that's licensed in your jurisdiction to help you understand those things is really important.
Right. All right. And then the third type that you mentioned was the Equine Act. So what would or would not be covered in those statutes?
Yeah, the Equine Act is a tick different. Those statutes, I believe it's 47 states that have them. And again, they differ a bit by state to state. But in general, the idea here is there are certain inherent risks involved with an equine activity. And the statute says we're not going to hold, landowners or horse owners liable for those actions. For example, if you crawl on a horse, there's an inherent risk you could get bucked off. All right. And so if somebody gets bucked off a horse, the Equine Act can be a potential defense to that because that's an inherent risk. Again, check your own state statute. Some states actually have broadened this to apply not only to equine, but also to other farm animals. Carrie, in Texas, your chickens would be covered by our Farm Animal Liability Act. We cover cattle, horses, hogs, etc. So check that in your state. Several states have leaned towards enhancing that protection to other animals. So that can be a really good protection if someone gets injured doing some sort of farm animal activity. A lot of those statutes have various exceptions to them, the willful, gross negligence, those sorts of things. If you're providing equipment to them and you provide bad equipment, that's generally an exception, but that can be a very useful statute as well.
Do you have any suggestions for farmers or ranchers in terms of record keeping for landowner liability? I'm just thinking about how, in general, I tend to ask my clients to make sure they keep good records. And I'm thinking out loud, I'm wondering if there's anything that they should be doing just in case that there is a lawsuit later on if somebody gets hurt.
In general, I think that there probably are exceptions to this, but in general, I think the better records you have, the better off you're going to be. So anytime that you do something to, make a dangerous condition safer, anytime you make any sort of warning to someone about potential dangerous conditions, those are things you need to be keeping records on. If you're hanging up signs, some of those statutes that we talked about require a sign be hung up in order to get the protection. You need to document, that sign was hung up on this date. Maybe take a picture of where the sign is located. I think that could be an important record to have as well. Things like if you are getting the waivers, make sure that everybody coming on the property has signed a waiver, not just the person who's kind of the ringleader of the group. Make sure you keep those waivers, have them on file. Those sorts of things can be really important if somebody gets injured.
What about larger farms and ranchers that have employees on their farm? Do you have any advice for those farmers and ranchers?
This is an area of the law that I probably know just enough about to be really dangerous. But what I would tell people is I would sure look into having workers' comp insurance for employees. And there are some states that require that. Some states, Texas doesn't, but some states require it. Some states require it if you have so many employees. But workers' compensation insurance basically is insurance that you purchase to where if an employee gets injured working for you, that's their remedy. They can go after the insurance benefits. And a lot of times that limits their ability to file like a civil lawsuit against you in court. And so that can be really important. Not having it can also lead to some potential issues where there's the potential that there are certain defenses that are not available to you in the event you do end up in court. And so if you have any employees, and especially if you have multiple employees, you really need to at least consider or look at the law in your state about workers' compensation. The other thing, at least that in Texas, the Farm Animal Liability Act, the Equine Act, other places, that may be beneficial in the event that an employee is injured if it's an activity with an animal. I've seen cases where that statute has been held to apply to independent contractors at least. Whether or not it'll apply to employee may be more of a question. That's been an issue in several cases I've seen here. But for independent contractors, at least, that can sure be a potential defense. That's something you might look into in your state as well.
Yeah, absolutely. And along the same lines, Tiffany, I'm thinking about some potential provisions that could be included in an employee handbook, perhaps. I mean, even just disclosing dangerous conditions, et cetera, to the landowner.
Yeah, the other thing on that same note, I think, is trainings in order to ensure that the employees know how to safely engage in the activities they're assigned to do, right? And that's where having those records can be really important. If you've got somebody who was injured using a certain piece of equipment and you could show that they had been trained on that equipment or they had attended, an extension, tractor safety day or something like that as part of their employment, that could be really useful as well in the event that someone gets injured.
Yeah, I give similar advice I don't know if anybody takes it, but I give similar advice as it applies to animal handling techniques.
For sure.
To go ahead and memorialize those techniques that are preferred in the employment handbook, and then make sure that you have employee trainings, document that you've done that, so on and so forth.
And that can be beneficial for a number of reasons. I think that's great advice.
Hey, so Tiffany, I know that you're not in private practice anymore, but how would you suggest that farmers ranchers find a good ag lawyer in private practice that could help them with these types of issues?
Well, the first thing I'd do is call Carrie, because she's a good ag lawyer that can help you with these types of issues.
Flattery will get you a long way on this.
That's why I'm here. No, I'm just kidding. There are a number of great ag attorneys. There are different ways you can do that. One way you can do it is kind of word of mouth and ask around, who maybe in your area does that kind of work. Another option is if you check out our website for the American Agricultural Law Association. You can just Google that, American Ag Law Association. There's a place there to find attorneys. There's a map that will pop up, and you can see attorneys in your state. That can be a good resource. The state bar in a number of states can be a good resource for agricultural attorneys. The National Ag Law Center, periodically, we're on a listserv where you'll see them send out, we got a phone call, someone needs this kind of attorney in this state, and people respond. So that can be another option as well.
All right. And so I know that you touched a little bit about this, about whenever somebody's interviewing an insurance agent, but do you have any advice for farmers or ranchers when they're interviewing an attorney to make sure that he or she really knows their stuff and understands production ag?
I do. I mean, and the first one's the same, right? Talk to them a little bit about your operation, kind of get a feel for what understanding they have. I mean, are they able to have a conversation with you about what you do? If they can, that's probably a pretty good start. With an attorney, another thing I always recommend, if they're trying to sell you a silver bullet, in other words, if you put your operation into this entity, you have nothing else to worry about, or everybody needs to use this type of entity, I'm very wary of that, because Carrie, unless you know a secret I don't, there are no silver bullets that fit all operations, that protect you from every potential danger. And so, that's something else. And I think it's really important with an attorney to have a good dialogue with them. If they recommend, I think you should consider an LLC. I want to know why. What are the pros and cons of that? Explain to me why you think that's a better choice than a corporation, for example. And I think someone who can really explain that and break it down for you is probably someone who is going to be a very good attorney and give you very solid advice.
Great advice as always, Tiffany. I really appreciate you coming back. I know this is your second time here on the podcast, so really appreciate your time.
Absolutely. Thank you for having me.
Tiffany, how can people find you on the interwebs? And including your social media links?
Yeah, for sure. So the best place probably to find me is going to be on my website. If you just Google Texas Agriculture Law Blog, that takes you to my website. I post information about ag law there. You can check that out. I have a podcast as well. It's called Ag Law in the Field. You can find that on your iTunes or your podcast app or on that website. Social media, I mostly post about ag law and funny things my kids do. On Facebook, you can find me, just look for Texas Agriculture Law. And on Twitter, my handle is @Tiff, so TIFF Dowell, DOWELL.
All right, excellent. Thanks again, Tiffany. Have a good rest of the day.
You too. Thanks, Carrie.
Bye.